Yes, Ms Kavanagh.
My lords, my lady, I've reached section 6 of the Human Rights Act. I hope not to take you long with. But you will find the relevant provision for your notes at A53 of the authorities bundle. But it does make it unlawful for a public body to act in a way incompatible with convention rights and imposes a duty on that body not to act in such a manner. Whereas here we say our operational duties were engaged on the 23rd of August when this child was being discharged from a hospital and a mental health section. The local authority cannot leave the child exposed to harm. We don't have a placement which complies with the registration requirements. Or for example, a children's home which is approved as secure accommodation. We would have acted unlawfully under section 6. And of course, in addition to that, would have acted unlawfully in regard to our duty to safeguard and promote her welfare and provide her with accommodation. The subsections which disapply subsection 1 of section 6 are in subsection 2. And the first one, A, is as a result of one or more provisions of primary legislation.
So this is in the authorities
I
bundle.
apologise, it's A53, my lord.
Thank you.
I need to be faster.
Yes.
So, of course, it would be disapplied, that particular duty, if we were under primary legislation, have authority to act in a different way. But, of course, given our primary duty...
Required to act in a different way.
Yeah, required.
So if the legislation says you shall pay money to widows but not widowers, the fact that it's a breach of Article 14, it doesn't compel the authority to act incompatibly with Article 14. They couldn't have acted otherwise because it's in primary legislation.
Thank you, my lady. My lady...
But this isn't about primary legislation,
no,
this is
and my
secondary
lady,
legislation.
Yes, and my lady, the short point is that section 6 was engaged here. I was just dealing with the other two subsections just to show that it was engaged here. And that essentially where...
Sorry, but so what are you saying, that this gives you power to act outside primary legislation under some other inherent power that the local authority has?
No,
so I don't understand your point.
Supports our operational duties under Article 2 and 3 when faced with a situation of imperative necessity. We would need to be guided by acting in a manner which was convention compliant, and so it's no more than that. I don't put it too high.
We were going through the sections of the Children Act.
We were,
and then we got to lunch, and then now you're on a different, obviously on a different point.
Yes, I was dealing with the duties that apply to a local authority under domestic law, and section 6, of course, brings into it's really to deal with Mr. Justice MacDonald's point of paragraph 76 of his judgment, the judgment under appeal here, which is at B33 of the core bundle.
Well, just going back a moment, you told us you were going to start with the statutory provisions, and the list I took down, section 22, 3A, B, section 20, 22A, and 22G, and then these two provisions of the Human Rights Act. Aren't you going?
I am going
omits.
I'm going
the key parts of the.
No, I'll go through the original list. Apologise entirely. The 6 issues I'll address in this order are: the first one was a local authority's duties and powers under domestic and convention law relevant to the child's case, which your lordship's just read out the list. The second is the ambit and scope of section 22C6C and 22C6D. The next one is the effect of the changes under the Care Planning Placement Case Review England Amendment Regulations 2021, which are the 2021 regulations, if I may refer to them as that. A short point at 4, which is the distinction between a power to place and the authority to detain, and how all of those 4 points feed into my 5th point, which addresses ground 5.
Distinction between the power to...
the power to place and the authority to detain. And all those 4 points, of course, lay the groundwork for addressing the 2 grounds. Number 5 is, my 5th point, is ground 1, the Article 5 requirements for compliance with domestic law. My final point is ground 2,
Good.
which in truth I reduced to whether the 2021 regulations made any difference to the availability of the inherent jurisdiction for a placement of a child in secure accommodation in an unregistered children's home, as previously settled by the Supreme Court in Re T. And those were the order I was going to deal with. So I did
So you're
bring
on
down.
primary duties.
Yes, I was just moving. I'll move briefly to.
What do you say? How does this obligation under the Human Rights Act affect the other duties under the Children Act? Do you say?
Essentially, the point is as set out by. It supports the points made by Mr. Justice MacDonald in paragraph 76 of his judgment at B33, in which he stated that further in the circumstances where section 6 of the Human Rights Act makes it unlawful for a public authority to act in a way incompatible with convention rights, where there is an immediate risk of breach of convention rights of an individual child, however that risk has come about, that if there is no alternative, the local authority can place a child in an unlawful placement to avoid such a breach. Within this context, is very properly conceded by the Secretary of State, where it is necessary to place a child in a particular place in order to prevent a breach of the child's rights. The local authority has a power, and that power may be a duty to place the child there. And in my respect, submission, it goes on to quote Lord Stevens, of course, at 177, but that's accurate, that's correct analysis of the position. And in short, where that takes us, place is that we're bound to act in a manner to avoid such a breach, and if there is a power, possibly a duty, we submit that the combination of Article 3 and the operational duties combined with the primary duty to accommodate, the duty to safeguard and promote the welfare of the child, plus the necessity for us to act in a convention-compliant manner, that provides a power to place a child in circumstances where that placement doesn't otherwise comply with the regulatory scheme. Whilst I acknowledge that power or duty, and in my respect submission, our respect submission is both, it deals with the power to place. In our respect submission, that does have an effect on the lawfulness of that placement for that interim necessity period. We're only talking about a temporary period. If I turn to, as the Lordship's indicated, we need to deal with the very important aspects of section, if I turn to the second point of section 22C6C and D in their ambit, and scope.
Yes.
It seems to be common ground that this is a placement that provides this child with care, constant supervision and control, and all parties take no issue, including the appellant, with the analysis of Lady Black at paragraph 129, which is at B69 of Re T, which confirms my Lord, the President's guidance, and my Lord's paragraph 3 of that guidance, which identifies that where an application is being made to the High Court under the inherent jurisdiction to authorise the deprivation of liberty of a child, highly likely the place in which the child will be accommodated will meet the definition of a children's home, or indeed a care home service. Looking then at the possibilities for subsection C of 22C6D, an unregistered children's home, either, as is suggested by the Secretary of State in his paragraph 16, which you will find in the bundle at C, forgive me, 4, electronic bundle, my lady, 138, where the Secretary of State says an unregistered setting is one that falls within what is a children's home, in quotation marks, but has not obtained registration. Secretary of State puts it as, this is the territory of section 22C 6C and constitutes a breach of the requirement in that provision for registration.
What does it mean, the territory? Either it's in the subsection or it's out. What is your submission? Is it in C or is it outside C? I don't understand
in our
territory.
respectful submission, it essentially falls outside of C in circumstances where the home is not registered.
Right. So you say it's not covered by C.
It should be covered by C if registered, but where it's not registered, it falls outside C. And we accept that's a closed list, as your ladyship invited me to consider it in an earlier question. But our respectful submission is that in fact this type of placement, where the child is being detained, so deprived of their liberty, I'm going to come in a moment to why I draw this distinction, falls outside the statutory scheme.
So it's not in D either.
No, it's not. I'm going to come to D, if I may, separately, but it is not in D. D is not a catch-all in our respectful submission, as is being submitted by the appellant.
So if it's a closed list, then does it mean that the placement is outside? It means the placement is outside 22C altogether.
It's outside the scheme, effectively. Because in our respectful submission, one has to look closely at what else falls into children's home, and we come to your lordship's judgment in read B and secure accommodation of the second type, that which isn't covered by section 25. So if I might just address that now, it's right to say that of course section 25 is the only statutory provision that permits the restraint or children to be detained in a place under the authority of the court. That's where we find the scheme. It's right to say that it's not permissible to place a child.
Just take this
Forgive me.
a little more slowly, because we haven't got 25 before. So we're looking at 25.
Yes.
Do you want to go to it? Do we need to?
Page
My lord,
75.
in my respect, submission, it's fairly clear from the judgment in Read T, your lordship's judgment in Read B, that that's the statutory scheme for the detention of children, and where that's unavailable, one has to look at the inherent jurisdiction. But I can take your lordship through those points.
That's what you want. I didn't think that's controversial.
It doesn't appear to me to be controversial at all across any of the skeleton arguments. But the position here is that regulations under secure accommodation, so the Children's Secure Accommodation Regulations 1991, which you have written in printed form, Regulation 3.
Sorry, so where are we going now?
My lord, my lady, under subsection C, children's homes, there are a number of regulations, not just one of which is
So we're back to
secure accommodation.
22C.
Yes, so we're dealing with children's homes and what other things that might fall outside of them, if I may. We have here a position whereby accommodation in a children's home shall not be used as secure accommodation unless in the case of accommodation in England it has been approved by the Secretary of State for that use.
Sorry, I don't know where you're reading from.
Forgive me, Regulation 3, my lady, I apologise.
Just a moment. Ms. Kavanagh, just you're now looking at examples of placements that can happen outside 22C. Is that right?
I'm looking at when a child is detained, is outside the section 25 criteria, is in a secure children's home, it falls in any event outside C because of the fact that it is.
Why?
Even if registered.
Why is it not a registered children's home?
A home can be registered, but it still could not be used as secure accommodation, even if registered within the meaning of subsection C.
It doesn't mean it falls outside C.
It's a narrower.
It means you can't use it unless it's also been approved by the Secretary of State.
And where it hasn't been approved by the Secretary of State, and I'm going to come, if I may, to that position, my Lord Justice Baker in Read B, and you will find the analysis of this section at B89 of the bundle, and that's the authorities bundle, forgive me.
That's in Re-T.
Sorry, this is Read B, my Lord Justice Baker sitting in the court. And this is Read B, dated the, forgive me, I'll just pull it up. So this is Read B, a child association of lawyers for children in 2020.
It would help me, just what is the proposition
Yeah.
you're seeking to make, you're asserting, supported by the Senate? What is your, what do you?
Regulation 3 prohibited the placement of a child like D in a children's home, registered or not, in any event, when you are using that accommodation as secure accommodation. And that was the position when the Supreme Court, in the course of Re-T, determined the case, and they did contemplate the case of prohibition, is what I'm coming to.
Well, I'm sorry. Would you just say again the proposition? Sorry to be fussy.
That a child, such as this child, who is in what I will in a moment establish as secure accommodation of the second type defined by Lady Black, in a children's home, if that children's home, even if registered, so registration set aside, is not approved by the Secretary of State as secure children's home, it cannot be used as accommodation for the child. It's prohibited.
Oh, yeah, children's home, even
And
if
that was the
registered,
position.
can't be used. Sorry, can you say that again? That just doesn't make
So
sense.
effectively, a accommodation that falls, that is not approved by the Secretary of State as a children's home, which is being used to as secure accommodation, is accommodation that is prohibited under Regulation 3. And that's essentially...
In one of these deprivation of liberty cases, supposing the young person is in a registered children's home,
Yes.
and so would ostensibly come within subsection C,
Yes.
you're saying that home can't be used to deprive them of their liberty, even if the High Court under the inherent jurisdiction has approved the doles, because it's not approved secure accommodation.
If it falls within the definition of secure accommodation set out in Re-T and by my Lord Justice Baker in Re-B, which is effectively for the primary
So
purpose.
all the authorisations that the High Court has made over the last few years authorising deprivation of liberty of young people in registered children's homes have been unlawful,
No.
because those homes have not been approved.
My Lord Re-T, the first placement for Re-T was an unregistered children's home.
Yes.
The second placement for Re-T was a registered children's home, but the complaint before the court in the Supreme Court was essentially that cut across the statutory scheme, because neither placement, registered or not, was approved by the Secretary of State.
You're now submitting that a child such as the child in the current case can't be put in a registered children's home if it hasn't been approved as secure accommodation.
My Lord,
But we're only in the position of having to authorise these placements because there isn't sufficient approved accommodation in the whole overall estate.
my Lord, forgive me, I'm submitting, but the Supreme Court's already determined the scenario proffered by the appellant, which is that where there's a prohibition on a type of placement, it still can be approved by the court using its inherent jurisdiction. Because that's one of the points that was before the Supreme Court, because the second placement, the first
I'm
and
just
second
simply writing down the submission that you were
forgive
making,
me.
and I just recording it doesn't seem to make sense.
Well, perhaps
I'm
if
afraid.
I draw back and withdraw it if it doesn't make sense.
Well, no,
and
but it's probably
resubmit
me.
it, I apologise.
You're drawing an analogy between the prohibition in Regulation 3, is this
Yes.
right?
Yes.
And the prohibition on a children's home that is not yet registered, but not falling within Regulation 27A.
Forgive me, I'm drawing, assuming for a moment that taking the appellant's argument to its logical conclusion that Regulation 27A covers an unregistered children's home. Therefore, prohibition in placing in those placements. There is an analogy to be drawn with the case that was before the Supreme Court and the cases that were considered by the Supreme Court, which is that there was a prohibition under Regulation 3 of placing any child, regardless of whether the children's home is registered or unregistered,
Insecure.
in accommodation which amounts to a secure accommodation where it hasn't been approved.
Yes.
And it seems to be common ground between the appellant and certainly the local authority that a child like CK was in fact in the second definition of secure accommodation, which I'll take you to Lady Black's judgment of you in a moment. But effectively, accommodation that was primary purpose category for detaining her. And in such circumstances, where the Supreme Court go on to analyse and to ultimately conclude that accommodation which is not approved by the Secretary of State, and that, which was, in our respective submission, many of them prohibited, could still be the subject of an authorisation by the court in terms of the detention of a child at that placement. And in those circumstances, this issue, by analogy, has already been decided by
the same ultra vires issue would arise if the appellant is right, or would have arisen in relation to Regulation 3.
Yes. Forgive me if I've caused confusion getting to that point. Lady Black's definition of secure accommodation for these purposes falls at 139. I'll come back to my Lord Baker's analysis of Regulation 3 in a moment. Let's deal with my primary proposition, which is that this child falls within it. And that is your authorities bundle at B72. So here, having analysed the primary purpose category, those specifically designed and then approved by the Secretary of State, Lady Black goes on to say there may, however, be placements perhaps more likely in the primary purpose category than the purpose designed category, which can properly be said to be secure accommodation within the meaning of Section 25, but which cannot be used as such because the children's homes and have not been approved by the Secretary of State in accordance with Regulation 3 of the 1991 regulations. Lady Black goes on to analyse that situation because she cautions at the end of that paragraph, of course, that is just the sort of circumstance that you wouldn't want to dismiss the argument that cuts across the statutory scheme easily. And having analysed it, and I won't detain you, you've read these paragraphs and you can do so again, but you will note in paragraph 141 that nevertheless she does go on, to borrow a phrase from the learned friend Miss Clement, to dismiss that suggestion that it cuts across the statutory scheme. Because the circumstances of necessity and the dangerous inadequacy of the level of provision across the system has led to this situation. And ultimately she concluded that if the local authority cannot apply for an order under Section 25, because there is no Section 25 compliant secure accommodation available, I would accept that the inherent jurisdiction can and will have to be used to fill that gap without clashing impermissibly with the statutory scheme. So to make good my proposition that in fact this Regulation 3 is a prohibition, if I might then move to my Lord Baker's dicta in the Court of Appeal in Re B, I think it's my Lord Baker at B89, was required to determine the meaning of secure accommodation for the purposes of the appeal before His Lordship. And at the bottom of paragraph 47, the last 3 lines of under H, similarly, a straightforward construction of secure accommodation, of Regulation 3.1, accommodation in a children's home shall not be used as secure accommodation unless approved by the Secretary of State for use.
Sorry,
Is that it?
just so we're absolutely clear we're on the same page. We're looking at paragraph 47 of my judgment.
Yes, forgive me if
B11
I give the
in
wrong
the
reference. That's B111. I apologise.
Yes.
I have given the wrong reference.
All right. Bottom of the page. Yes.
Thank you. Having cited what Regulation 3 is that it excludes certain accommodation from being used as secure accommodation, but does not alter the definition of secure accommodation. And of course, specifically it excludes a children's home being used as secure accommodation. Under the regulation, under the terms of regulation.
Yes. So
in our respect for submission, Regulation 3 is, I didn't use the language excludes or is a prohibition, the wording of it clearly states shall not be used as secure accommodation if it's not approved. Nevertheless, the Supreme Court went on and we'll deal with this in paragraph 141, but it's right to say that the Supreme Court went on to consider that the inherent jurisdiction was still available to authorise the detention of the child at such a place. So it's not the position.
Well, can you just show us, because although she deals with both the unregistered children's home and the Regulation 3 prohibited accommodation, she then just focuses on the potential criminal offence committed by the provider rather than there being unlawfulness in relation to the use. Can you just show us where she returns to that, if she does?
So it's, if I start just with framing what she is then dealing with in the latter paragraphs by going back to her paragraph, Lady Black's paragraphs 129 and 130, which we'll find at B69. So in particular, in paragraph 129, Lady Black identifies that paragraph 130, the question of whether accommodation here was secure accommodation again is not possible to make a finding at this late stage about T's specific placements. It was asserted that both were. One was registered, one was unregistered. Caerphilly had conceded that certainly the first one was a children's home. But she goes on to say, however, the question of what accommodation falls within the definition of secure accommodation for the purposes of section 25 does merit consideration in more general terms here, because the arguments before the Supreme Court were that these homes which had this primary purpose category, the second category, both of which it was said he was in, were cutting across the section 25 statutory scheme, and therefore the inherent jurisdiction was unavailable to them. So her ladyship then goes on to analyse what is secure accommodation through the subsequent paragraphs, which includes looking at the details of what would be approved by the Secretary of State and what wouldn't. Your Lordship will see paragraph 134, my Lords and my Lady will see that she talks about the designed for category, which would fall within that which is likely to be approved by the Secretary of State. And then moves on to 138 at B71, where the Secretary of State indicated that design for are more likely to be approved by the Secretary of State, but then in that middle of that paragraph from G onwards indicated I would agree with this view. In doing so, I'm influenced by the fact the second category of secure accommodation should take its colour from the purpose designed category. Effectively setting out that this will therefore limit the class of at the bottom, placements that can properly be termed secure accommodation within section 25. Where the placement is not secure accommodation, there can be no question of the use of inherent jurisdiction cutting across the statutory scheme. So those that are approved, that puts that issue to bed. However, then when she goes on to consider the purpose designed category, the question of it cutting across the statutory scheme is of significance. And she goes on, nevertheless, to identify that this is a situation whereby it wouldn't cut impermissibly across the statutory scheme. So it's specifically considered in paragraph 141 and goes on to explain the situation whereby the situation that's developed in extremis, but at 143 at B73, it has to be recognised that when a local authority applies under the inherent jurisdiction for the court to authorise a secure placement which is either not in a registered children's home or is in a children's home that has not been approved for secure accommodation, these placements will not satisfy all the requirements. And my lady then goes on, her ladyship goes on to draw a distinction between that and those placements which are unregulated, those types of placements which are children's homes which have just not been approved and unregulated accommodation. But then at 145 moves to address there the circumstances in placements type 1, which were the ones which were unregistered, and the situation in relation to the offence. But at no stage does her ladyship then go on to say that a placement that her ladyship's already identified at 141, which is of the second category, a children's home which is secure accommodation being used, would effectively not be capable of being authorised by the inherent jurisdiction. So it does not.
So she doesn't return to it.
Well, insofar as it is returned to, if there is a sorry. Yes, I've addressed my learned friend's just pointing out that the last sentence of the 141 it essentially decides that point in our respectful submission.
So when she says fill that gap, she's referring to both of them.
Yeah.
And
what she then goes on to do,
1452.
what she goes on to do is to say there's a second point I have to deal with which concerns me, which is that one of those placements, so children's home, used as secure accommodation were both of them. At least one of those placements is a placement that was unregistered, and we now have the additional factor of it being an offence, and then that's where the judgment moves to in 145.
Yeah.
So in our respectful submission, I'm grateful to learn a friend that that's the line drawn. The inherent jurisdiction is available. And in our respectful submission, the analogy was not an improper one for Mr. Justice MacDonald to draw across. In his judgment, it was not, given that line of reasoning, secure accommodation.
The inherent jurisdiction is available for what?
For a child who is in the equivalent, who's in secure accommodation.
Yes, but to declare what or order what?
The detention of a child in a placement which is unapproved by the Secretary of State as secure accommodation, but which is nevertheless secure accommodation.
As within the definition of secure.
The definition of secure accommodation in a children's home, registered or not.
and this is all part of your second submission, which is about the ambit and scope of section 22C6, and it starts with the premise that a placement which is an unregistered children's home is outside the scheme altogether.
Yes.
And so that nevertheless, the inherent jurisdiction can authorise the restriction of a young person's liberty in such a placement.
Particularly where it's been used as secure accommodation. Because, of course, well, my lord, yes, I accept that summary. But if I may, I ought to deal with why I say, I've moved on to touch upon some of the factors about cutting across the statutory scheme, but if I go back to deal with the point about why I say it doesn't fall into D, thank you. In our respect, submission D is not a catch-all for all other placements which do not fall within A and C.
Well, now-
Essentially, if we could just...
You're now saying that the current definition of the current what falls within D now is a closed list. Is it?
What falls within D now is essentially other arrangements is not confined only to unregulated provision.
So
However,
before the regulations were changed, other arrangement was was unlimited, or not as or relatively unlimited. Now it is limited, confined, is it, to what appears in the regulation, Regulation 27A.
prior to the amendments, it was dealing, and it was termed to deal with unregulated accommodation. However,
Anything. In theory, anything. Other arrangements,
well,
regulated or unregulated. Could fall within D.
unregulated accommodation is specifically the wording that was used in chapter 3 of part 4, so regulation 27. It's headed a placement in unregulated, and moreover the the schedule which it is referred to, that you have to go through certain criteria, is again headed unregulated.
Sorry.
So prior to the 9th of September, that was the position.
22C6D
Yes,
just says other arrangements.
it does, and that
Doesn't say
wording has never
regulated.
changed.
Doesn't say regulated, or it says
And
any
it does,
arrangement which
other arrangements which comply with any
regulations
regulation.
made for
Yeah.
the purpose.
So they're regulated other arrangements.
So the first, which comply with the regulations made under the section. And prior to the 9th of September, the regulations made under the section were regulations that had headings.
I see, they're not regulated, they comply with the
Sorry,
regulations
forgive
under
me.
the section.
Forgive me. The
No. I mean, as I read 22C6, it's other arrangements which comply with any regulations which may be made. It's not only regulated, it includes unregulated.
yes, it does.
And that is confirmed that it could, as a matter of construction, include unregulated by the original Regulation 27,
Yes.
which talks about before placing C in an unregulated setting under 22C6D. So that indicates that as drafted, 22.6CD is capable of including regulated and unregulated. But Mr. Drabble's point is that following the change in the regulations, and particularly the change in the wording of 27 and the list of 27A, it is now not possible as a matter of law to place a child under D in an unregulated setting.
Yes.
Do you agree with that?
We agree it is not, that under that there's a prohibition on placing a child in an unregulated setting after the 9th of September. However,
Can
it's
I
right to
just write
say,
that down? Sorry.
sorry,
Prohibition against placing a child.
in an as found by Mr. Justice MacDonald, which I haven't appealed the finding,
Yeah.
but there is a prohibition on placing a child, and the intention of that legislation was a prohibition on placing a child in an unregulated setting if they're under the age of 16 after the 9th of September.
And we've now got the memorandum, which well, what do you
Well,
say that confirms your?
yes, in paragraph
Interpretation.
6.7. It confirms it in the clearest terms in our respect for submission. It says we are amending the 2010 regulations to prohibit placement of a child under the age of 16 in other arrangement settings with limited exceptions. The effect of the amendments will be that looked after children under 16 can no longer be placed in unregulated settings, while continuing to allow other arrangements placements in alternative regulated settings by exemption. I'm just going to pause for a moment there before I read the second part. This goes then to my lady's point that if one looks at the list under regulation 27A, 1A, that sets out a list of regulated placements, regulated not necessarily by Ofsted, some by the CQC, in which children under 16 could possibly be placed, and that remain lawful. That remain a placement that's available under D. They are not within the definition of children's homes, and as pointed out, and I won't repeat it, in fact that's specifically demarked within that regulation. And the fact that that list is closed to a list of regulated placement, in our respect for submission, supports the plain effect of the amendments, which is set out in the explanatory memorandum at 6.7, which is to no longer be able to place the child of that age in an unregulated setting. So the prohibition found by His Lordship Mr. Justice MacDonald was that there was a prohibition on unregulated settings for children under 16. That is, in our respect for submission, perfectly open to the judge to find on the available information. And of course, when one ties that up, as your lordships have, and I mean, takes the point of the language used by Lady Black when carefully delineating what is regulated and what is not, and what is registered and what is unregistered within paragraph 58 of RET, it's clear that children's homes remain regulated despite the fact that they might be unregistered.
But you've already agreed that an unregistered children's home doesn't fall into C. You made that submission earlier.
Yes.
So where does it come into? Because it's not in D.
No, and because we are unregistered, because we haven't complied with the statutory scheme, we are not within placements as defined in subsection 60.
The fact that a children's home may be regulated does not bring it within the scheme if there's no registration.
And in particular, if it's being used to secure accommodation, because it's the both elements here. Because even if it was registered as a children's home, still couldn't be using a children's home for secure accommodation.
So in the explanatory memorandum, when it refers to children's, it must be referring to a registered children's home. Because there's no provision for unregistered children's home being used on your submission within the statutory scheme.
Yes. It goes on to give some definition.
It's really odd. It's really, I mean, it goes back to my lady's point. It's really odd that we're dealing with young people under the age of 16 and it's excluding a category of children's homes because they're not registered.
Well, in truth, as set out by the Secretary of State in paragraph 16, where you have something that meets the definition of a children's home, you look to see in 22C6C.
Providing care for children.
Because they provide care for children, they are a children's home in every other respect, but they have not complied with registration. So bringing them back within the statutory scheme, bringing them back within the regulatory scheme is essential, and your Lordship's guidance provides for that. But at the point at which we are, unfortunately, in the territory of either awaiting or applying for registration in that urgent emergency situation that we find ourselves having placed a child just released from a hospital, we unfortunately, in those circumstances, where we are detaining the child at that placement, and that's the key as well, falling outside of the statutory scheme. And it's in this place where all of the judgments, and I wouldn't need to take your Lordships through a rehearsal, all the judgments in RET have this underlying and express provision that children, where they fall outside of the safety regulatory network, the inherent jurisdiction is available as the ultimate safety net for them.
Where do you and Mr. Drabble differ?
I say,
I mean,
I
I
say,
confess, Ms. Kavanagh, my impression, and I'm sure it's my mistake, was that you and Mr. Auburn were aligned in your interpretation, but it now seems to me as though you're not, because I think Mr. Auburn, unless he's going to
no.
recant, is going to say that that children's homes do, unregistered children's homes do still come within C.
Well, to the extent...
He's taken his mask off as if he was about to
I wasn't sure if you were directing something. I'm happy to rise it anytime you
No,
should.
no, I don't. No.
It's fair to say that though my primary submission is that it falls outside the scheme, I would, in the alternative, accept the Secretary of State's position, because in truth, it's on any analysis, it does not fall in our respect submission in D, and it does not fall in A and B, and therefore it either falls within C, and it needs to be, they need to get their registration sorted.
But do you want to? Are you supporting Mr. Auburn's written
I
position
will
or
go
not?
on the record as supporting the Secretary of State, but I do advance an alternative. I go further than the Secretary of State. So even in the event that that's not accepted by this court, then we would submit that the position is that therefore we would fall outside the statutory scheme.
And that has the advantage, and this is where you perhaps do differ from Mr. Drabble, that you're not then cutting across an express prohibition, because the scheme is silent about regulated children's homes that are not yet registered or not registered for whatever reason. They're just not within the scheme. So you're not cutting across a prohibition, and nor is there any question of ultra vires.
And moreover, that's made all the more acute when the child is being detained in such a setting,
Yes.
because it's
And
being used to secure accommodation.
You say it's an ultimate security safety net. That's when the court has to step in and exercise its inherent jurisdiction.
So as to reduce the stress of a learner from the Secretary of State and reduce submissions, I do not seek to undermine anything the submission made. That's the primary submission. I won't go behind it.
We're sure or not.
I do go further though. I do go further, and I, in my respect for submission, the Secretary of State's submission is as it is, and our submission is even if it's not within C. It's certainly not within D, because it falls outside of the scheme. Because when you look at what D is, and we've set it out in our skeleton argument, I needn't go.
But just, please will you just address my lady's point head on?
Forgive me.
Are you saying that there is in fact a lacuna, the way it's being drafted, there is a lacuna in the statutory scheme, and that therefore means there is less or possibly no inhibition, certainly less inhibition on the court exercising inherent jurisdiction, because it doesn't cut across it.
The lacuna arises where it's being used to secure accommodation, effectively, within the second definition of secure accommodation
The court wouldn't be required, wouldn't get involved unless it was being used to deprive the child of her liberty. That's the only circumstances in which the court is required to approve a placement.
Not necessarily. There may be circumstances which fall within the other types of which the Secretary of State submitted in RET, where, for example, the child's in a therapeutic placement, where the object of the care and support is therapeutic, so the primary purpose of the placement is not for the primary purpose of detaining the child or restricting its liberty, but nevertheless the child is deprived of their liberty in that therapeutic setting. Lady Black addresses that in her judgment. She concluded that that wouldn't, for her purposes, fall within the definition of secure accommodation in that second category.
But nonetheless, the inherent jurisdiction could be used.
But nevertheless, the inherent jurisdiction can be used in those cases.
Yes, but the court only gets involved where deprivation of liberty is. Courts don't have to consider place. The court doesn't have any role on placements. It's kind of for local authorities to decide where to place children.
So essentially then, to answer the point head on and to make the concession that I should, then I don't seek to go behind the Secretary of State's submission. I'll leave that untouched from my submissions, if I may. and I'll leave it to the Secretary of State to
Well,
advance
it's
those
completely,
arguments.
it's completely different to your submission.
Well, if he's the Secretary of State, essentially I will accept that as an alternative. But I do say that it's a closed list and that we fall outside of it. But I recognise that there is an argument to say that it falls within C. But I don't seek to go further than
So
that.
if we're not persuaded by Mr. Rawburn,
Then
you say nonetheless, it doesn't matter because in that the consequence is unregistered children's homes fall outside the statutory scheme.
perhaps I'll rest as an alternative to Mr. Orban in those circumstances then, but that I go further than the Secretary of State in short and seek to advance that alternative. I've moved well beyond any. I'm not going to just rehearse the ground because we've fused my point about PECT of section the changes in any event. So I'm going to move on if I may very briefly. The distinctions about the power to place and the authority to detain, in fact, we've touched upon, but I do just draw your attention, if your ladyship answered me the question at an earlier point about, well, in fact, I was being asked whether I'm in fact saying at any stage that the court authorises the placement. I'm not. The court authorises the detention, and it's right to say that Lady Black at paragraph 160 of RET, when she was in fact dealing with the issue of consent, turns to address this a little more closely, and you will find that at B77 of the authorities bundle, and my lady identified as my lord the President did in the Court of Appeal in RET, that it will be addressing the question of deciding the factual matrix of whether a child is detained or not, goes on to say that making an order, whether under section 25.119 or under the inherent jurisdiction, authorising the local authority to restrict a child's liberty. Moving just a sentence on, the latter is a prospective order, authorising but not requiring a local authority to take steps in response to events which is anticipated are likely to occur. The focus is upon whether or not the factual circumstances justify the restriction proposed should things transpire as the local authority predict. And what is also clear from that judgment is that because of the fact that the court is in territory of the inherent jurisdiction, where children are not within the quality standards and the important registration requirements within their placement with those relevant safety standards. In addition to the fact that some of the points raised about the placement plan and the care planning by a learner friend, the court has set out, and the Supreme Court sets out, that there have to be safeguards built in to the inherent jurisdiction for it to be available. One of those safeguards is where the placement is an unregistered children's home. My Lord the President's guidance is central, and bringing the placement back within the regulatory scheme is essential. But you will find, if you go back to B75 of Lady Black's judgment, where she addresses the points about appropriate procedural safeguards at 153, it's not just the President's, my Lord the President's guidance. She refers in the middle of that paragraph at E to the by requiring the structure imposed by section 25, and that's referred to earlier in her judgment. If you look at the top paragraph, she's talking about REC detention and some of the safeguards in that judgment. It's right to say that her ladyship said that there is provision for the appointment of a guardian. By requiring the structure imposed by section 25, should also observe that an application to place a child in the equivalent of secure accommodation, the President is to ensure that proper procedural protections are built in for the child. This matter is also dealt with in considerable detail by Wall J, as he then was, in Re-C Detention, Medical Treatment, and Sir James Mumby and Re-A. In addition to the President's guidance, and those make a contribution to the procedural protection of the child. Before the Supreme Court, of course, were one of the primary submissions in the case was about those inherent procedural protections, and where Lady Black earlier in the judgment said she's not going to detail them all at this point. And I don't seek to do so. Responding to the point about care plans and evidence of the restrictions and what's in place for a child, which was set out in, you will see, Regulation 9 of the 2010 regulations, the sorts of things that are required when you're placing a child anywhere. It's also the case that in Re-C, Wall J, at paragraphs, the former President Sir James Mumby, paragraph 51 of the A case, identified that there needed to be evidence of the child's concrete situation, and goes on to detail the sort of information that is required to be placed before the court.
Well, Lady Black deals with this in 155, doesn't she?
Yes.
She summarises.
And including care plans and all of these sorts of evidence needs to be brought before the court.
Regular reviews as well.
Yes.
And liberty to apply.
Yes. But importantly, it's not just limited to those inherent procedural protections. It's about placing before the court evidence about the regime that the child's being exposed to, what's happening in that placement, and my Lord the President's guidance, it plainly addresses that sort of information. So it is the case that there are safeguards within the inherent jurisdiction, which have been built up through the common law, and of course that was one of the issues before the Supreme Court, whether they were sufficient for the purposes of Article 5 and the procedural protection required under that.
There's a danger, if that's the right word, of that developing approach and role for the court, which the Supreme Court really have given extra wind to with what they've said about the President's guidance, is the court turns itself into something of a regulator itself. And it's the court that's checking that the registration has happened. It's the court that's checking that the care plan and all these other things, which are not really the court's normal business, have been undertaken. And so there is a danger there that that happens, and it's unwelcome for the court to be drawn into that sort of level of management of a placement.
Lord, it is in truth in practical terms happening in that way.
I'm sure it is.
And the learned judge in the first instance, Miss Justin MacDonald, of course, in the third judgment in this case, which is the most recent judgment, has addressed some of those issues.
Yes,
about,
he deals with
He deals head on with that point, that that's a position that we should not be in, and therefore the shortest possible time periods need to be applied to this to keep with the period of the fact that this is effectively a measure, an interim measure to protect children over a short time.
Yes, and I'm bound to say that the President's guidance, which gets a lot of limelight in these, this judgment, was drawn up by me with enormous assistance from Ofsted in order to give more power to Ofsted's elbow, really, not to draw the court into becoming the policeman of it all, but there we are. The Supreme Court have relied on it as a safeguard in the way that you describe.
Yes, but it is now part of the safeguards, given the approval by the Supreme Court of it in that way.
But the consequence is that cases are coming back to courts, often more than once a week. These cases, for these matters to be reviewed, micromanaged by the judges.
Sometimes daily.
Sometimes daily, and it's just
Depending on the child's circumstance. It's overwhelming.
It's not appropriate.
There's no question.
No, it's a matter that has taxed me since I became president. It just doesn't seem, in the end, compatible with the role of the court, for the court to have developed this jurisdiction in order to fill a gap, which then becomes consolidated into a regime. When really it is for the statutory bodies to be undertaking that role.
Well, more than that, I would align myself in this regard with Mr. Drabble, in that it's for the government and under that local government to ensure that there is sufficient available provision for children, not just social care provision, as highlighted by the Honourable Mr. Justice MacDonald in that third judgment. Mental health provision for children of this age, including secure mental health beds.
Yes.
That is not something without its impact. The reduction in mental health services is not something that doesn't have an impact. It has an impact on the number of children that are going out into the community. But those are matters that I'm not here to make submissions about. Evidence hasn't been filed about those matters, and I can't take it further, no more than anecdotal. But Mr. Justice MacDonald has identified
The
those.
more the court gets drawn into becoming, with the very small r, the regulator, without inspectors, without the ability to visit the premises or engage with them in any way, the court hears second hand from the local authority and the guardian what the accommodation is like, and from the young people as well. The danger is something appalling will happen in one of these placements, and there'll be legitimate public interest in what happened, and if it's found to be wanting, it'll be said that, well, the judge approved this. We brought it back to the judge, and the judge responsibility. I feel extremely uneasy on behalf of the judiciary who are undertaking these cases, that they're being progressively drawn into that role, which does not seem a comfortable one.
My Lord, the learned judge at first instance adopted and advanced the submissions of Miss Clement, which were to record that the court is not authorising the placement or making it in any way lawful, nor the care plans in that placement lawful. What the court is doing is authorising the detention, and therefore it does not prevent the exposure of the persons running that home to prosecution or other remedy.
No. In the end, on a case-by-case basis, there's a young person in the centre of each of these cases, and something has to be done, and we're doing what we're doing at the moment, but I've given voice to my unease more directly to the ministers sitting in a different seat from this one. But, and there we are.
My Lord, just turning, I'll jump to the Article 5 point, if I may, which was my 5.
This is your point about ground one as well.
Yes. You have a very similar submission made by all respondents to the appeal, that the essential requirements of Article 5 in terms of compliance with domestic law is a focus of upon the detention. It must have a legal basis in domestic law. Lady Black uses that phrase at paragraph 90 of RET, and that's at B6. Accordingly, the detention must have a legal basis in domestic law, and the law must be of a quality which is compatible with the rule of law. In our respective submission, that is an accurate statement, that it is the law, the position, and it's right to say that even Article 5, 4, of course, which is the provision which relates to the provision under Article 5, which addresses other essential criteria, identifies that everyone who is deprived of his liberty by arrest or detention, so these children, shall be entitled to take proceedings which the lawfulness of his detention shall be decided speedily by a court, and his release ordered if the detention is unlawful. So it not just in the authorisation of the detention, but in the review function of the court, which of course is the dual function that a court under inherent jurisdiction would be undertaking, particularly where there's a review of the authorisation listed after the initial authorisation is given. It's right to say that the focus there also is on the detention, not on other compliance with domestic law. The lawfulness of the detention is the focus. 1D, of course, under Article 5, which relates to minors and their educational supervision, requires the minor's detention by lawful order. And that's, of course, not necessarily a court order. If a child's detained under the Mental Health Act of 1983, that would be lawful. But it's also right to say that at paragraph, so forgive me, so paragraph 89, Lady Black identified the requirement for confinement to be in accordance with a procedure prescribed by law. And then at 150, we have all cited the same paragraph to you. She addresses head on the submission, Lady Black addresses head on the submission, that a detention is not in accordance with domestic law where, and before that court, as I've already sought to establish, was placements under which were secure accommodation, neither of which were in compliance with Regulation 3 of the 1991 regulation, and potentially a children's home unregistered, so there were and an offence being committed under Section 11, and the court was considering those circumstances, registered, unregistered, use as secure accommodation, in general, not just specific to T, but general, and nevertheless concluded that the authorisation itself by the court brings the deprivation in accordance with domestic law. So in our respectful submission, when Lord Stevens at paragraph 171 also emphasises, and this is at B82, so for positive operation measures including a deprivation of liberty to be permissible under Article 5, any deprivation of liberty must be both lawful under domestic law of the United Kingdom, open brackets, which includes the inherent jurisdiction, close brackets, so specifically goes to the point at paragraph 175 to say that that domestic law, which he is expressly considering the inherent jurisdiction. And he refers back, of course, for compliance with Article 5, with scrutiny of care plans and information before the court, which is referred to by Lady Black in paragraph 87. And he refers back to that at B60. The focus is, if there were any doubt, despite that clear dicta, is the domestic legal basis for the detention itself. That comes from the Talat Tepe and Turkey case referred to by my learned friend, the Secretary of State, at paragraph 62, and you will find that in the authorities bundle at B660. Even if the court makes an order for authorising a detention and either erred in the application of the law, that doesn't render the court's authorisation unlawful. And you then take that from the Dayoub and Netherlands case, which is cited in our Scottish argument, and you'll find that at B481, paragraph 45. So it's in short the lawfulness of the deprivation and not the underlying placement, which is the focus of the compliance with Article 5 for domestic law, and the position of the appellant has been, in our respects, which this argument has been decided by the Supreme Court. It's not wrong for Mr. Justice MacDonald, who was carefully considering that case, to apply it to the circumstances before him, and in our respects submission he was bound to do so. He did not err in doing so. And it's then turning, if I may, just check that out. Yes, we do concur with the Secretary of State's submission that a breach of national procedural law impacts on compliance with Article 5, where the breach relates to the power to detain. You will find that in the Secretary of State's submission, the electronic bundle of 146, his paragraph 48. This child, CK's detention has been authorised by lawful court order throughout and beyond the 9th of September. In short, then, paragraph our final submission of 6, our 6th point, is that the 2021 regulations did not make any difference to the availability of the inherent jurisdiction for D in secure accommodation and unregistered children's home, as settled by the Supreme Court in RET. I've in fact gone through those submissions, but I'll just check if there's any additional point to make under that. Yes. Lady Arden sought to identify paragraph 181. You will find this, forgive me, I failed on this occasion to write down the. Yes, paragraph 181 identified the sorts of circumstances that are coming before the court and the exercise of the inherent jurisdiction, where the local authorities need to create urgently a bespoke and highly specialised solo placement for a child to meet their immediate needs by keeping them safe while therapeutic work is carried out, or in the alternative, registered placements or alternative registered placements being identified. Lady Arden goes on to say it's these placements which Secretary of State's case will often not be registered at the time that they are required, and therefore we are concerned with a very limited and exceptional class of case, which I recognise is over those small group of children in the whole looked after population are, as has already been observed by my lords and my lady, overwhelming the work and the business of the family courts, but they nevertheless are a relatively exceptional group of children. Mr. Justice MacDonald himself found at paragraph 77 of his judgment, and my lords, my lady will find this in the bundle at
33.
Yes, I apologise. 33. Yes, thank you. Yes, thank you. Identified that the statutory scheme, so the changes to the statutory scheme brought in by the 2021 regulations, first did not oust the inherent jurisdiction. And in our respect submission, that was open to the learned judge to find.
You say they filled an unintended lacuna.
They do. But even if I'm wrong, and the Secretary of State's analysis preferred, and I don't stand in the way of that.
Then it's covered by RET.
It's covered by RET, and in any event, therefore it isn't ousted. And he was not the learned judge following the dicta, and it's part of the reason why it was not necessary for him to determine where the placement fell, because ultimately before the court it was agreed that in any event, even if it was a prohibition, particularly given the Regulation 3 point, this was something that was already covered by the Supreme Court. Then, so he goes on, of course, to set out also the second point, that it didn't cover the whole ground within the meaning of AG and de Keyser, and I won't get into the pronunciation. But he particularly draws attention that but for the exercise of the inherent jurisdiction, a child would be left at risk of significant harm, cruel or inhuman and degrading treatment or death, because it's not possible by lack of resource or other compelling considerations of necessity to comply with the amended statutory scheme. So even were a child placed in circumstances which do fall within section 22C1, 22C6D, and then are caught by 27A and are under 16 and not in one of those listed placements, their circumstances, nevertheless, in our respect submission, it was open, following the parity of analysis in RET, for his lordship to find that that was still available, the inherent jurisdiction was still available to protect those children, because the whole ground was not covered by the statute, and these children were still left in those circumstances of extremis. And so in our respectful submission, nothing has changed by the regulations of 2021 in relation to unregistered children's homes used for secure accommodation. And then, if I may finally, yes, I'll address Lady Arden's point at 191, which has been referred to by the, sorry. My learned Julian, who ought to get credit for his point, does identify just building on where this lacuna may have arisen, that there was an amendment to section 63, forgive me, of the Children Act, is my reading of it, yes, that's correct. In 2000, which previously expressly prohibited placement in an unregistered children's home.
Well, hang on, you can't. But
No,
you've
I'm
taken us to paragraph 191.
No, I'll move. I forgive me. I'll move.
Lady Arden. And,
I'll come back to that if it's necessary. So 100.
Lady Arden, 191.
Yes, thank you.
if the point that Mr. Spencer's made needs to be put before the court, then please do it. But I think it's just not going to work.
I won't jump around. I'll deal with Lady Arden.
Reading it out without us having the material in front of us.
Forgive me. Yes. And it may be that that's the sort of thing I need to give some thought, and it might need to be a side
Yes.
note. But if I just perhaps deal with where I was. Forgive me.
So 191, quoting
So,
wrongly.
Lady Arden, hold on. Lady Arden refers to, in the previous section, to Bromley's family law, and in particular, Lady Arden's reference there was, forgive me, I'll find the, yeah, so paragraph 191, the reference includes courts have traditionally declined to define the limits, but goes on to say in the second paragraph under the de jure limits, there is no inherent power to make orders prohibited by statute. For example, committing a child into local authority care. What isn't addressed and analysed by Lady Arden is what is the prohibition being ordered by the court. It is the court ordering something which is prohibited by statute. And here in our respectful submission, the court is authorising a deprivation at a place, and that place might be a prohibited placement within the meaning of the statute, but within the meaning of the regulations. But that was thus under Regulation 3 for secure accommodation. So it's in our respectful submission the case that the court is not, in fact, ordering something which cuts across the provisions set out and relied upon by Lady Arden in 191. The inherent power is not making an order itself that is prohibited by statute.
But I think that Mr. Drabble goes on to look at paragraph 192, the first sentence, where Lady Arden says, in my judgment, and I note this is a point also made by the ALC, if section 11 had criminalised the use of the unregistered homes, the court could not have exercised its inherent jurisdiction. So that's the point, and obviously on his submission, the use of the unregistered homes by the local authority has been prohibited.
Yes,
But you say it's outside the statutory scheme altogether.
I do.
So in that case,
This doesn't apply.
That deals with it, but in any event, there wasn't developed argument here, and there may be, because there's a difference in language used by Lady Arden than the language used by Lady Black.
It's
It
open.
does talk about authorising the placement, and it's not the placement that's being authorised, not made lawful by the step taken by the court. The step taken by the court authorised the child's detention, and it may be that had that been an issue that was being articulated, if it had not been over, if it had been central to the case and argument had been developed upon it, that's an area that would have required further submissions. So whilst I do say in any event this falls outside the statutory scheme, the other difficulty with that point raised at 192, again, which might have been addressed directly if this was to be a central point in the case, was how does one reconcile that with Regulation 3 of the 1991 regulations, which on a plain reading, Your Lordship in Re B found was effectively excluding placement in such a accommodation, a children's home, if it's being used to secure accommodation, a prohibition. So how does one have that parallel? So in our respect of submission, it's not something that should be determinative of this appeal, and it's a matter that, given that it is obiter, given that is not in the majority judgment, in our respect of submission is not a matter that is the guiding light which this court should follow as to the approach to be taken. And Mr. Justice MacDonald was not wrong to analyse the matter in the way he did, following the judgments of the Supreme Court. If I may just take a moment to
Yes,
just
certainly.
check if this is a point I should raise now, or if I should deal with it in due course.
I suspect something that would benefit from being looked at overnight
I
and
think so.
circulated.
Yes, perhaps
tomorrow
if I
if
can
you're
see
going to run
perhaps
it, I
I'll
think.
circulate a note in time for reply. I'd be grateful. Thank you. May I just turn my back and check if there's anything else? I'm most grateful. Thank you.
Nothing else? No. Thank you, Ms. Kavanagh. Now, Mr. Roach, it occurs to us that it may be more appropriate for you as the guardian to make your submissions after you've heard from the Secretary of State and Ofsted.
Of course.
I realise Mr. Orban's getting no notice of the fact that I was about to say.
We heard the whisper earlier. We gave 5 minutes notice, my lord.
Is that convenient, Mr. Would you like a short adjournment before you address us, or?
Well, Lord, I anticipate that I won't be completing my submissions this afternoon.
No, that's us.
So perhaps if I can get started,
Yes, certainly.
I think overall we're pretty good for time. I think 2 days was actually scheduled for this, but we surely won't be needing that all up.
No, I think as my lord explained, that it was the longer time estimate was given in case we had to deal with the appeal from the second judgment.
Oh, yes. Of course, I've forgotten about that. Seems an age ago. Well, lady, I'm happy to get started and find a convenient moment around 4 o'clock or ish to break,
Very good.
if that's convenient. Lords and lady, the Secretary of State is very grateful for the opportunity to intervene in this case and to make written and oral submissions to you. It's right that I should make clear, obviously the Secretary of State considers this matter to be an extremely important and serious circumstance, and the Secretary considers that all children who require care of the sort provided by a children's home should be in a children's home that's registered with Ofsted. That's the primary starting point. And as will be seen and evident from this year's amendment, that's particularly important for under 16s whose care cannot appropriately be met in forms of accommodation that are not required to provide care. That's obviously a very serious matter. In these submissions, what I'd aim to cover is I would start by grappling with the issue of construction that's been battered about today, and then after that, it may be that that's really all I deal with before before the end of the day, and then after that go through the grounds. But I anticipate, similarly to Myrna Friends, that the focus will be on ground 1 and ground 2 is sort of wrapped up with what's already been said under ground 1. The first point then, under the construction issue, an issue was raised early on as to the fact that Mr. Justice MacDonald had chosen not to deal with this point on 22 capital C, 6, C or D, which is a point that's obviously occupied quite a lot of the court's consideration today. And one of the reasons for that is because the judge considered it wasn't necessary to do that to determine the case before him, the matter he was asked to decide. And if I can put it in very short form, and I'm sure you'll realise that a lot more lies behind the next sentence, that the issue of operational necessity or imperative necessity, or however it's phrased, applies with the same outcome in this case, whether you see the legal issue to be grappled with as one to be grappled with under C or D. That you come back to an issue of imperative necessity and the principles which the Supreme Court was concerned with in re T, and you get to the same ultimate outcome. And I think that must be what considerably lay behind Mr. Justice MacDonald feeling he need to decide that issue of C or D. And ultimately, we say that the same applies in our case, that while I'm about to embark on this issue of construction and C or D, or the 2021 regulations, at the end of the day, it doesn't alter the end outcome.
Well, Mr. Drabble says it tightens, if he's right, it tightens the noose, or whatever you want to say, tightens the screws on the local authorities to sort it out.
Sure.
I'm sure noose isn't the right.
Screws.
But it's more than a choice between C or D. But Mr. Drabble's submission is that an unregistered children's home is neither in C or D.
Yes. Well, I'll come straight on to the construction point then, because that's obviously where we're headed. The intention of the amendment was to address unregulated accommodation, not unregistered accommodation.
Well, that was the government's intention.
Yes.
Yeah.
Yes. And particularly to make clear that placement of under 16s in unregulated accommodation was to be dealt with in the form of the regulations, and wasn't permitted other than by the strict limitations within 27 capital A. And following on from that, we say the intention was to deal with unregulated rather than unregistered, because unregistered is already encompassed within 22 capital C 6 small c, and I'll say exactly what I mean by words in a moment. I just want to outline where I'm headed, and Milady rightly raised the point earlier on that we're using the skeleton, the words within the territory of C, and what we mean is that, again, when I say C or D, I mean 22 capital C, subsection 6, C or D. That D, other arrangements, should not be used to evade the C requirement of registration, except in circumstances of imperative necessity to avoid an Article 2.3 breach in the manner discussed in Re T. And that isn't a lacuna or a gap. The issue is one of non-compliance with the requirement in 22 capital C 6 small c of registration, where a setting is a children's home.
So, but just focusing on the words of the regulation that was brought into force, how can a placement in a children's home in respect of which a person is not registered under Part 2 fall within C?
Well, no, yeah, best if I get up the regulations we're talking about in front of us. Already, if places is in fact operating in circumstances that it is to be true that it is in fact a children's home, then it should be registered and it should be considered under C.
If it is registered and it's a children's home, it will be considered
Yes.
under C. No difficulty with
Yes, and if it's not, if it is in fact satisfying the conditions of being a children's home but not registered, then it has that breach, which leads to further consequences.
So it's not in C.
Well,
Where is it then?
it's not within C because it requires registration.
Yes. Yeah.
That's the point.
Yeah,
The point is
not in C.
well,
It's not in C, but it might be in C in the future.
yes, and it should be considered as a matter of breach of the requirement of C.
Okay, so
It's not that it then falls into D, because that simply evades the requirement of registration in C. It's that if it's operating as such, it needs to get registration. That's the point.
Right, so it's... So this is this makes some sense of in the territory. So you say it's an inchoate C or whatever, it's a
circumstance.
It's a C
which,
it should be in C, but it's not yet.
right there.
It's
because there
not
is a
registered.
requirement not met.
And the inherent jurisdiction is used, therefore, to supplement the statutory scheme by allowing the detention to be authorised pending the requirement of registration in accordance with the President's guidance.
Precisely, and it's very similar. The comparison doesn't need to be exact. It's very similar to the situation in Re T of a failure to comply with a requirement. And then you go into the President's guidance territory I shouldn't use. You go into the President's guidance, and that's the mechanism to direct the circumstance back to within the statutory scheme. And that's used in the manner of Re T in circumstances of imperative necessity to avoid a breach of Article 2.3. And only in those circumstances, and that's why we get to the President's guidance and its strictures.
And has the amendment to the regulations affected that in any way?
We say no. In this sense, that D, and I'll take you through it, pre-amendment and post-amendment. But Secretary of State's position is that little d, other arrangements, was never intended to cover placements requiring this high level of care, which is the very area of C. It was never intended to encompass the same thing of a children's home. And we agree with your point about a closed list, that yes, the 22 capital C subsection 6 is a closed list. And a point was raised, I can't remember which of your lordship's raised it, but about whether that was a closed list just now or that's the change. The Secretary of State's position is it's a closed list, yes now, but it was to start with.
So your contention is that an unregistered children's home was never within D?
Correct. Not intended to be within D.
Not
Was
intended.
not-
Was it interpreted as being?
It was not in. The Secretary did not intend it within D, because that was the very area of C and the requirement of registration. So you don't escape the requirement of registration by calling it something else. Now, and I can take you to the explanatory notes and explanatory memorandum, but to directly answer your point before I get there, what happened was that in practice local authorities were using it in a way which didn't match Secretary of State's intention.
So it was being used
It was
by
being-
local authorities to place children in unregistered children's homes, or to justify the placement.
It was being used in practice by local authorities in a manner which they purported to use within D.
Yes.
In unregistered children's homes, relying on D.
I believe so.
And indefinitely. As it
Well-
were. Well, that was the Secretary of State's concern, was it? That it
Well,
was being used.
the time, I'm not sure we need to get into
No,
that issue.
but it meant that the requirement of registration was being downplayed.
Circumvented, I suppose.
circumvented.
Well, there are all sorts of words we could use.
Well, circumvented. Yes, right. So you're really agreeing with Mr. Drabble, aren't you?
Well-
in a sense that it was. And be careful here. Tightening the screws on local authorities a bit.
Well, I'm not sure I would necessarily agree with that proposition. The Secretary of State, the amendment was made to reinforce what the Secretary of State thought the
Yes,
position
but
was.
if local authorities were circumventing the requirement of registration by resorting to D, then tightening up the definition of D closed the door on local authorities and tightened the screws on local authorities to make them comply with the registration requirements.
Well, yes, the Secretary of State believed that it was never believed that D was. Sorry, beg your pardon. I'll start the sentence again. D shouldn't be used for unregistered children's homes. It had started to become, or was used by some local authorities in practice for that purpose, and the regulation was intended to stop that. Subject to, and I'll be using this phrase a lot over the course of my submission, subject to recourse to operational necessity to prevent a breach of Article 2 and 3, which is the very point within 3T. So if I can take you through where you see that, I mentioned the explanatory note to the 2008 Act, and that's at D1. With the authorities bundle. Paragraph 40, which is at D2.
Yes.
So you see, at D2, the authorities bundle, paragraph 40, placements under section 22, capital C6, small d, may include, for example, supporting young people who live independently in rented accommodation, residential employment, supported lodgings, hostels. So more independent forms of accommodation, which would be more appropriate for older children of this group. And that is also reflected in the regulations themselves. If you go to Authorities Bundle C32, which is Schedule 6 of the regulations.
Sorry, can you give me the page reference?
Yes, Authorities Bundle C for Charlie 32. If you see at the bottom of the page, Schedule 6. Matters to be considered for placing C in accommodation in an unregulated setting under 22 6D. And then the matters listed in paragraph 1, and over the page you'll see matters such as tenancy status, financial commitments involved, the C in their affordability. So you see the flavour of that as being in the nature of more independent or semi-independent forms of accommodation. And I've explained the point that that while that was the intention of having that provision, we're aware that local authorities have been using it in another form beyond independent and independent forms of accommodation. And we then have the 2021 amendment. And I think you've been shown the explanatory memorandum to that amendment, which I won't take
Spare, isn't it?
back to, been handed up separately, but that touches on that issue and also uses the phrase mainly because it was able to encompass other things such as those things in 27 capital A. Now,
So the policy explanation, as described in the policy background section of the memorandum, paragraph 7.
Does that tell us what the Secretary of State, the then Secretary of State's thinking was?
yes, I would 6.6.
That's what you cited.
Yes.
I was looking at the policy background in 7.
Yes, and 7.3 has also been cited.
7.3.
Yes.
And you submitted a short time ago that local authorities were circumventing the requirement for children's homes, some of them to be registered, all of them to be registered, by using D. And one of the purposes of the amendment was to stop that. Now that purpose doesn't find any reflection in the explanatory memorandum, does it?
Well, Lord, it goes some way to explain that 27. Well, I mean, the use of the regulations was not only about the independent, semi-independent, and you've seen 27 capital A is more broadly framed.
7.5, first sentence of 7.5. The intention of on the ban on unregulated placements is to ensure that that's what the ban is.
It doesn't say anything about registration,
Doesn't.
which is your point.
Yes, the point is that D is only about unregulated settings. The Secretary of State didn't consider that D should be used for that purpose, so it wanted to make clear that it shouldn't be used for that purpose. That's the point. It wasn't that it was a change.
We looked at this, each of the three of us, over lunchtime, and the document falls into the trap of assuming that the aim is for young people under 16 to be in children's homes or foster care if they can't be with their parents. It doesn't grapple with the registration or non-registration of the children's homes. I don't think that's mentioned at all in the document.
Yes. Well, I accept that, but from the Secretary of State's perspective, this should always have been covered by the fact that C has a requirement of registration when children's homes are used. That's the point. So it wasn't a change in that respect. You want to make clear what really should always have been the position, or what the Secretary of State considered had always been the position, which is a requirement of registration of children's homes or a setting that in fact operates as a children's home in C. That requirement of registration should be complied with where you're operating a setting that is in fact a children's home. And that's the way the matter is viewed.
So the policy is that the children under the age of 16 should either be in foster homes or children's homes, and if they're children's homes, they have to be registered because that's the requirement under little c.
Yes.
And
Yes.
that's implicit.
Yes,
in the scheme and whilst not being mentioned in the memorandum.
yes, yes. So the appellant's argument, as I understand it, is that the 2021 regulations brought in a change to ban something that previously hadn't been banned, but from a Secretary of State's perspective, well, this was always a matter that if you were in fact operating a setting that in fact was operating as a children's home, then you need to be registered. So the breach or the flaw or the issue is one of lack of registration.
well, you and Mr. Drabble may disagree about what the law was, but at the moment it seems to me you're in agreement as to what the law now is.
Well,
The interpretation, the construction.
And the issue we're dealing with is one of lack of registration. That's the problem, which the inherent jurisdiction.
I don't think you are in agreement
Yes,
about the
I don't
construction.
think you are
I'm
right.
not sure I haven't in mind whether I'm in agreement or not. I'm saying what our position is.
Yes,
I'm wrong. I'm obviously wrong. Okay. Ignore my comment.
Well, if I can say what our position is, and then we can
Yeah.
work out whether
And
I'm
then we'll-
agreeing or not agreeing. I don't know. At some point in the day, I've given up trying to work out who I agreed with and disagreed with.
No, it's been an
I
interesting
just know
day.
my position. The key issue is what is the legal matter which the inherent jurisdiction is facing, and that legal matter is an issue of lack of registration, and that you can describe it as you will, whether it's a gap, something missing or a flaw or whatever, but that issue, if I can just use a neutral term, of lack of registration, is in nature indistinct or sufficiently similar to the legal issue which the Supreme Court was grappling with in Re T. And I can take you to that and show you that. And that's really part of our case. That the matter, while the circumstances aren't the same, we haven't moved away from the same principle.
It would be different, or it might be different, is this right, if the local authority was seeking authorisation from the court for a deprivation of liberty order in relation to an unregulated setting, let's say one of the old-style semi-independent homes that were previously acceptable under Regulation 27 but are now prohibited by Regulation 27A. If that were what was being sought, that would cut across Regulation 27A and be directly, because that would be an unregulated setting. Is that
Well,
fair?
I'm not trying to have to answer that. It may well be, but I think what would I've got to avoid using the word territory. What we're dealing with is identifying a legal issue and working out the point at which it may cut across the statutory scheme. And in Re T, and I'll show you where you see it, but in Re T they were dealing with an absence of registration where registration was required. And here we're dealing with absence of registration where registration is required. And the solution to that, as the Supreme Court have told us, is having regard to operational necessity, Article 2.3. It is permissible to be going outside that requirement for a period of time, strictly having regard to the President's guidance, with a view to bringing it back within time. And you'll be aware of Miss Justice MacDonald's other judgment recently, which hasn't been appealed, which also dealt with the issue of where you get to the limits of that if there's no intention to comply with the President's guidance. So our submission is that a placement of this type already came up against the 22 capital C6 small C requirement of registration for children's homes, because it was in fact operating in circumstances which require registration, and that brings us to that legal issue, which is not distinct or of the same nature of legal issues as that considered in reason.
Have you finished your construction arguments? Or are you
Pretty much. I'm very happy to take questions.
Could you just go back to Mr. Drabble's paragraph 36?
Yes.
Exactly what I'd just gone.
I just wanted to make absolutely sure I was wrong in what I said a few minutes ago. As I
Yes.
the consensus was that I was.
Would you like me to have a
Do
go
you-
going
do
through each
you-
of these?
Let's go through. Hand it to me. Go through from A. Start with A and go on.
Right. Okay.
Do you? Do you? I think you've agreed it's a closed list.
It's a closed list. We agree it's a closed list.
And what about B?
Well, I hope I tried to explain what our position is, which is if a setting is operating in fact and circumstances where it requires registration, then the issue is it needs to get registration to enable it to come within C. So it's in breach of the implicit requirement in small c.
Is that agreeing with what Mr. Drabble says?
I don't know if I am agreeing with him or not, because I don't know what he. It depends what you mean by within. I mean, it requires registration.
Well,
Otherwise-
he goes on from that proposition to saying, and the fact that it's a closed list,
Yeah.
to say, and the use of the word other in D, to say, therefore it's in D, and that's where you
that's
draw
really
the line.
yes. That's probably the point we need to concentrate on, because that's where we clearly
Yeah.
part company. So whether we agree or disagree up till
Yeah.
then, that's the issue. And on that, if I can put the matter simply, and I've departed from my notes, not sure where I am on those, but if I could put it this simply, that whatever is within D, we can say what is not within D, and that is the very thing that C requires registration for. You can't use D to just wrap up and get around anything that requires registration under C, because then what's the point of requiring registration under C? And of course, that then takes you to the re-T point about what you do when you've got a circumstance that's in non-compliance with the requirement in statute.
So your position is closer to Ms. Kavanagh's position.
I've stated my position. I've stated my position. And I'm very grateful for Ms. Gavin for saying that we don't disagree. I'm sure we probably don't, but I just want to not.
Not sure why.
Yes.
Right. Mr. Drabble, as I understand Drabble's case, is that it may have fallen within D under the previous regulation, but it doesn't fall within D now.
Yes.
So consequently, it's neither in C nor D.
Yeah.
And you say that's pretty close to your position. But your point is that the scope for using the inherent jurisdiction is greater because of the importance you put on registration.
Well, we say the situation was the same pre and post the amendment. The issue is still small c, and the requirement of registration, and that, if you can call it flaw or legal issue or whatever terminology you want, that's the issue, and that hasn't changed pre or post the regulations, because regulations are about D, not C. The regulations are about other arrangements, and the issue we're concerned with is a place is operating in fact as a children's home when it hasn't got registration. And you can't get around that by calling it something else, by saying it's another part of the statute. That's the point. Well, no doubt, I can take you through the legislative maze as to how you get to that point. I think we've set it out in our skeleton, paragraph 13, that you start.
Sorry, I think what
Yes.
you're saying, just trying to make sense of it. If it's a children's home, it's regulated whether it's registered or not. And so, thinking in terms of Venn diagrams, there's a circle, a big circle of children's homes, and if you are a children's home, you're regulated and you're in that circle. There's a smaller circle within the group of children's homes which are registered, and you've got that core.
Yes.
We've got the list in section 22 C6, A, B, C, and D. It's a closed list, and so you can only be within that list if you're on it, and if you're a children's home, you can only be in that list if you're a registered children's home. That doesn't mean there isn't the broader circle buzzing around C of children's homes which are not yet registered, but that doesn't mean that they in any way fall into A, B, or D.
I think the way I'd answer that is I think the way Milady...
They're waiting to be registered. They ought to be registered. They're not quite registered, but they're not. Doesn't mean they're in any other category.
I think Milady's answered that in the morning on the regulated, unregulated issue that at least, if you didn't intend to read, what I noted, and at least what our submission is that if a setting is in fact operating in circumstances where they are properly described as a children's home, within that definition, they require registration. That doesn't mean that they're outside the system of regulation. It means they're within the system of regulation because they require registration.
And in the ordinary operational decisions that are made within a local authority, it will sometimes be necessary to place children in this wider category of children's homes which are not yet registered, because that's what you've got to do, because
The President's
the
guidance.
right to go, they haven't got any other choices, and the need a placement. And that's permissible because it's an operational necessity. And where that involves deprivation of liberty, you also come to the High Court and you get permission for that, because that home is on a journey that's expected, and the Supreme Court have underlined this with my guidance, that it's moving to become registered, and moving to come within section 22C6C.
Within tight constraints.
Within time.
Within tight constraints.
So all of that,
Treaty
if it's
and
going on, and it is, in no way means that it's in D.
Correct. It's not out with the system regulation, it's within the system regulation.
And that explains your position in the subsequent case. What,
Yes.
Your
Yes.
in your contention to Mr. Justice MacDonald was that
If you're not planning to get back
if we're
into the
planning,
system-
if you can't or won't comply with the registration, then you're outside the President's guidance, and the inherent jurisdiction can't be used.
and that's when you cross the line of parliamentary sovereignty.
And the attractiveness of Mr. Drabble's and Mr. Barnes's submissions are that they're very clear, but they hang a lot on the closed list. Once you assume the list is closed, then it becomes a self-fulfilling prophecy, because the words are so tight that if you're an unregistered children's home, you're not on the list, and so you can't be there. That ignores the practical reality of local authorities actually placing young
Yes.
people in unregistered children's homes for the time being.
Yes.
And that means that it's a mistake to think that the list is closed, full stop. You can't ever place a child anywhere else, because local authorities do, on a pragmatic basis, because there's no other alternative from time to time.
Yes.
Does that?
Yeah, yes, I think we are saying the same thing. Sometimes I have to stop and think whether we are saying
No,
the same
well, we
thing. I
have
think
time
are.
overnight.
And
to-
that, I think, takes me back to a point that was mentioned earlier, that somewhere in submissions I used a phrase which was deliberately inexact, which was we're in the framework, or the territory. It was a deliberately inexact phrase. We're in the territory of C. But what I was attempting to encapsulate by that is what the President has just said, obviously much more eloquently than I could. That we it's not that you're not within C, you are within C with a breach which you're trying to get that within. Reference RT, reference the President's guidance. And the important point of that is that it has enormous limits, which we saw in the more recent, subsequent, it's just a MacDonald case, where those limits can be, you can come up against those limits, where the court will say, well, no, actually, you've reached the limit here. You're now asking too much or going too far, and the inherent jurisdiction can't do that. And that's the line we have to draw. Read T, and we say the case being appealed from was on one side, the permissible side of the line. The second MacDonald judgment was on the other side of the line, where the local authority or the local authorities were saying that, you know, in situations or can't or won't, they should still be able to use the inherent jurisdiction, and that goes too far. So that's where the line is somewhere in between
And
those
the Secretary
two.
of State is content, presumably. You've not appealed Mr. Justice MacDonald's judgment.
We haven't appealed, no.
You're content with his formulation.
Well, the Secretary has not appealed, and it was, and the outcome was, well, I mean, well, I choose my words carefully. We can. I'm happy to hand up Secretary of State's skeleton in that case, and you can see what we said. But we were saying, and indeed Ofsted was saying, we were both saying that the inherent jurisdiction cannot be used in that circumstance.
Yes. You were
Mr. MacDonald expressed it slightly differently.
Ordinary.
Yes. He expressed it slightly differently, but I don't want to agree with the word content because, you know, we haven't appealed. And our and my skeleton and my friend's skeleton were quite similar to the judgment. I can just leave it at that. That there are limits on the inherent jurisdiction, and that's an example of those limits. And that's why the strictures of RET and the strictures of present guidance are real, and one has to keep in mind imperative necessity, what is strictly necessary to avoid breach of Article 2, and that's quite a high threshold and something that's tightly constrained. Obviously, that causes other issues with cases coming back before the court and so on, but there we have it.
Is that a convenient moment?
Yes.
Then have you?
I'm obviously happy to answer questions on what we
Yes, well, I think that's been helpful, indeed. So we'll start again tomorrow morning at 10:30, in some confidence of finishing during the course of the morning, I would anticipate. Very good. We're very grateful to you all, and I'll see you at 10:30.
Is that? No. I didn't know what the difference is. Well, I just took silver.
Should be wearing that nice.
I took silver seriously. I didn't know it was supposed to be. No, I did buy one. I must just pick up the wrong one trains.
A little bit mix and match.
I'm impressed that you can tell the difference.
Ready for us to leave?
From the black. From the black.
Are you content for us to
I
leave
went
things
to
in
walk
court
off
overnight?
Right.